it's a right to live there. So it's a little different. So, no, it's different in Puerto Rico.
No sé. Pero sí bregamos con gente que sabe.
So, but here it is necessary, and so when you have that conversation, it is useful. I usually recommend that both spouses' names go on the title to the property, even though it is not required if only one spouse is the borrower. So let us say, for example, you have a spouse. I'm gonna reverse the normal situation. Let us say it is the wife that has a job, and the husband stays home and takes care of children, okay? Usually, it's only the wife that can be the borrower because she has the income. She has the money that comes in. So she's the borrower. She fills out the loan application. Here's my job, here's my social security number, here's my bank account assets. And the husband doesn't even fill out the loan application. So in that case, it's only the wife who would sign the promissory note. And that means that if the wife doesn't pay, the bank can only sue the wife. It does not affect the husband's credit. If the husband has separate money in a separate account that they've had since they were a little kid, if the husband owns a 1967 Mustang, he gets to keep it. No problem. The bank cannot go after the husband if it's just the wife that is the borrower on the loan. However, the bank will require the husband to sign the mortgage because that is permission for the bank to foreclose if the wife doesn't pay. So the bank can send the husband out of the house, but they can't take his property or his bank account or his car or any of those other kinds of things. So it's very normal for only one spouse to sign the note, but both spouses have to sign the mortgage to give permission to foreclose. And in terms of title, I think this is done more in Latino cultures than in Anglo cultures. In most Anglo cultures, it is very normal. It would be weird to not put both names of both spouses on a home they're going to live in. But I see it very commonly in Hispanic borrowers to only have a husband's name on the title. And that is probably a mistake. Because if one of them dies, if the husband dies, and the wife's name was not on the title to the property, it now becomes necessary to go through a probate action with a court. And that will take 3 months, 5 months, 6 months to resolve who owns the property. But if you have both the husband and the wife on the title, on the deed, as the owners, and maybe the husband dies, then the wife will now own the property, automatically. All you have to do is record a death certificate. So you get a death certificate, you go to the courthouse, you record it, that's all that is necessary. So it makes what we call estate planning much easier, and it's much nicer to the surviving spouse if their name is already on the title. But I will tell you, many of my Latino clients, we typically find that for some reason, they just put the husband's name on the property, which is very unusual in the Anglo world. In the Anglo world, you better put my name on that property. Never put children. Never. I'm sorry. Let me make this clear. Never minor children, under 18. Never. Now, if they're 17 months and 17 years and 8 months, okay, that's fine. I mean, that might make life a little bit easier. But 12 or 6, no, absolutely not. Never, 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 never. It will be terrible. Very, very difficult to do that. So please don't. There you go. Any other questions? All right, thank you very much. Good luck.
I'm not sure Mr. Otto's going to stay a little longer later on. If you have any questions, please, by all means, feel free to ask them.